Hello, and welcome to our session titled Adulthood Ahead Essential Planning for Parents of Children with CDM. I'm Lydia. I am a clinical education support intern at the Myotonic Dystrophy Foundation. Today's session will run for 1 hour, and our presenter has asked if you have any questions that you just ask them throughout the presentation. This session will be recorded and available in the Zoom events platform for 2 weeks. MDF will post the recordings to our digital academy later this year. And if you ask any questions, please wait for the presenter to call on you, and I will bring you a microphone so that we can all hear and our friends on Zoom can hear as well. And so today we have Liz Holmes. Liz has practiced law in central Indiana since May of 2014. While she serves the whole state of Indiana, her office is located in Indianapolis. Her practice at the law office of Elizabeth A. Holmes, LLC, is focused on estate planning and elder law. When Elizabeth is not practicing law, she enjoys practicing hot yoga. She finds that taking time for her own self care on and off a yoga mat helps her to be able to serve others even better. She enjoys spending time with her family and friends. She joins her parents and brother Matthew at Butler men's basketball games regularly. She enjoys trying new restaurants and enjoying quality time with those around her. She can also be found reading a good book or watching a movie. So now please give a warm welcome to our presenter, Liz Holmes.
Thank you, Lydia. I appreciate that. When they ask you to write a bio, I never know really what to write. So hopefully that was exciting to hear. So we are going to touch on a lot of different topics today. As Lydia indicated, as you have questions, ask the questions, because when you ask a question, someone else can learn. All right, you see my phone number and my email. I do offer free initial consultations. I'm at 93rd Meridian, but we do via Zoom, phone, or in person as well. Anything to be helpful. All right, next slide. There's my office address. We're at 93rd and Meridian, so no parking garages to contend with. All kids need a little help, a little hope, and someone who believes in them. We all need a little help, a little hope, and somebody who believes in them, right? Nobody is an island unto themselves. So that's just something to remember. I like a good quote, and it's always good to remember you're not alone. I think as a sibling of a person with special needs, my brother has autism, dyslexia, and Crohn's disease. So not myotonic dystrophy, but still has special needs. It can be easy to feel like you're alone, and you're not. Disclaimer, this is not a replacement for any sort of consultation, because everybody's facts and everybody's situation is different. Everybody's different. Table of contents, we're going to talk about a lot of different things: guardianship, supported decision making, power of attorney, special needs, wills, and special or social security. If you have any other questions about anything else, estate planning and elder law, I'm happy to answer the questions. So this is not a, you can only ask about these questions. Also, I don't generally read slides. I know I just did for the purposes of table of contents, but take as many notes as you wish. All right. So we're going to start with guardianship. Who has heard of guardianship? Anyone? All right. Yeah, a little bit. Who wants to know more about guardianship? Yeah. Okay. Oh, we're on to a good start. So, a guardianship, you see the legal definition. So, I'm not, as promised, going to read the slide to you, but briefly, what a guardianship is, it's when you step in the shoes of somebody else. So, if you've ever been taught or taught your kid how to, or any of your children, I should say, how to ride a bike, if you think of guardianship as you are on the bike with them, versus power of attorney, where you're running alongside them and they can tag you in, but you can only help if they tag you in with power of attorney. Whereas with guardianship, you are literally on the bike with them. So with a guardianship, what you're also doing could be in a number of circumstances. It could be for a minor. It could be somebody older who has dementia. It could be somebody turning 18 who's not quite ready to adult yet. So a guardianship could be all sorts of things. The definition of somebody who needs a guardianship is an incapacitated person. Incapacity, much like any diagnosis, can be different per person. So I'm assuming that if you have myotonic dystrophy, you are not the same as everyone else who has myotonic dystrophy. Everybody's different, yeah? So incapacity can mean all sorts of things, and it's a spectrum. When you are getting guardianship over someone, you could be incapacitated because the person is a minor. You could be incapacitated because The person is unable to adult by themselves. And nobody can really adult by themselves, but I hope that makes sense when I say that. They need a little bit of extra help compared to somebody who is neurotypical who is 18. Any questions on that? No. And you can ask questions as I go through. There are different types of guardianships. So, the big umbrella of a guardianship, there's temporary and a permanent guardianship. Temporary would be a situation where you have an emergency situation. And unfortunately, for the courts, turning 18 is not an emergency. It may be for you, but it's not for the court. A temporary could be life-ending decisions are happening over the weekend, a minor child, a parent has died, and they don't have anybody legally to act on their behalf. Placement needs to happen in a nursing home. There's no one with legal authority to act on that. There could be all sorts of reasons why there's an emergency, but it typically lasts about 90 days. A permanent is a bit of a misnomer because a permanent is only in place so long as it's needed. But you're not going to court every 90 days. And as much as I don't mind going to court, I'd like to skip it for you if we can. So there is that. Permanent. So if you have a loved one with special needs, whether it's myotonic dystrophy, whether it's autism, whether it's Down syndrome, whatever it is, that they need a little extra help, you likely, if the circumstances will not change within 90 days, want to go for a permanent guardianship. That way you're not bonding with the judge any more than you need to. With a guardianship, full guardianship is guardianship of the person and estate. So there are two parts. Person allows you to make healthcare decisions for the person, allows you to make sure they're in a safe living environment. Think of it everything but money. That's what guardian of the person does. Guardian of the estate is not I've died and an estate is opened. We'll get to that. But guardian of the estate is I have assets that I am unable to manage. That's what we mean by guardian of the estate. So if somebody got a direct inheritance, if somebody sued and got a lawsuit settlement, if somebody was left things directly into and are in a will and aren't able to handle it, a guardian of the estate could be needed. Yes. What if they just can't handle their own money? That was the question. I'm happy to repeat it. So, what if they just can't handle the money? Just can't handle the money can mean all sorts of things. Are they bad at managing money? Because guardianship is not a mechanism to avoid making bad decisions. There are plenty of people in the state of Indiana or otherwise that are not under guardianship that are making bad decisions with money or bad healthcare decisions. So it's not a mechanism to do that. If it's a minor because they're 5 and they are unable to because they're 5 and they're incapacitated due to minority, or they have dementia, or they have some sort of diagnosis that is rendering them unable to make the decision, then we talk about guardianship. Does that help clarify? Yes. It's talking about an adult. So if the mental acuity is not there, then yes, that could be an example of why a guardianship could be helpful. Yes, you have a question, Kristen.
What is the difference between guardianship and power of attorney?
We're going to get there. Stay tuned. No, you're fine.
Our guardianship of the person and estate too different because we're getting guardianship of my son
Yeah.
and we're going to do medical and financial for
Mhm.
him because he's not able. Are they different
So if
or
you
the same?
they're different parts.
But it can have guardianship, but it can cover both.
Correct.
Okay.
Yes. So when you petition for guardianship, you can petition for a limited guardianship, and that can be as limited as I take the person to the doctor's office and attend meetings with them and help them make decisions in that. It doesn't have to be across the board medical decisions, or it could be the full kit and caboodle, person and estate. Yeah. When I first started practicing law, and it'll be 11 years on the 20th, I would go for guardian of the person a lot of times if we're talking about an adult who doesn't have a lot of assets, because the judge is not going to want to do an accounting if there are no assets. So effectively, where is the estate? And it's been interesting because over the last 2 or 3 years, we've had doctors' offices refuse to talk to parents who want to pay with their own money, by the way. We're not talking about the person with special needs. We're talking about they wanting to pay the bill, but because they're not guardian of the estate, the doctor's office won't talk to them. And so we've been having more full guardianships in recent years to address that, even though it's technically not needed. Yes. You're so welcome. Good question.
So the person is an adult, they're not going to agree with the need for this. What are
Okay.
the steps you take prior to doing that?
So with the guardianship, every adult guardianship starts off with a physician's report. And so we would ask the MD to complete a physician's report to render an opinion, and as much detail as possible is preferable. So I have a lot of judges that I'm in front of that I've been in front of again for close to 11 years that are asking for more and more information because if you're going to strip somebody of their rights, which is what you're doing when you get a guardianship and resetting them to minority, they want to make sure they're making the right choice. So first, can't fault a judge for doing their job. All right. So you'll have the medical report, then you'd have the hearing. If they are opposed to it, they are welcome. They're entitled to notice of the hearing, which is always entertaining depending on the day. And they're able to voice to the judge that they don't agree. Oftentimes, in my experience to date, somebody not agreeing that needs one and there being medical evidence that indicates they need one, it still goes through, but it depends. I'm not saying that as a guarantee, by the way. I'm just saying, in my experience to date, if somebody has evidence that they need one, even if they are objecting to it, there have been times where it has gone through. Yeah. It's not easy. It's not easy for you. It's not easy for them. It's not easy for whoever's going to be guardian. And that's something to think about too. It's not just whether there's a need, but will they cooperate with you? Because if they're not cooperating with you, you could be taking on a big headache. And who wants that? Yes, you want to help. I get that. I'm not trying to diminish wanting to help. But if they're not going to work with you to allow you to help, then that might be something else to consider. So, back to the question a minute ago, can you get person and estate at the same time? Yes, you can. So, you'll want to read the court documents that I hope your lawyer, I hope you're working with an attorney, is drafting. And you'll want to make sure you understand it. I think too often other colleagues are not explaining and or clients are not reading and or they don't remember. I try to draft documents in a way that are easily understood. And so you want to make sure you understand what you're getting and what you're not getting. So, step one, meet with an attorney. And I know that sounds self serving, but it's really not. I don't get my medical advice off of Google. I hope you don't either. There are times to meet with a professional, and this is one of them because I have questions that you might not be thinking of because it is in my day to day wheelhouse. In January, this is not on the slide, bonus tip for you. In January, my parents, brother, and I, my brother has autism, dyslexia, and Crohn's disease, which is why I do this work, went to New Zealand and Australia. We went on a 2-week cruise. So great. But one of the things we got to do was we got to go to Weta Productions. If anybody has seen Lord of the Rings, yes. Okay, Weta Productions is a place where the prostheses are made, the costuming, the props, all the things. And they were talking more about their process, having a sword that's lighter than an actual sword. And while that may seem obvious now, when I say it out loud, I would not have thought of that. I'm not in movie production. And so there are different questions that, in my nerdiness, I'm going to ask that you might not think to ask. Then you start with the physician's report. For an adult guardianship, every adult guardianship starts off with a physician's report, an MD. Indiana is lucky in that we only require one MD. In Kentucky, they require an MD and a psychiatrist. So they require two. And up until recently, they were requiring jury trials. We don't do that. Generally, it's about a half-hour hearing if it's uncontested. If it's contested, it could go longer. In Marion County, they believe everyone turns 18 on Wednesday. It's always been that way. I don't know why. But anyway, tried explaining that to a judge once that people turn 18 on other days. But anyway, whatever. But it's about a half hour. One good thing that has come from COVID is that hearings can be attended virtually as long as you consent and the judge consents. Marion County, since COVID, has been doing everything on WebEx, which is a clunkier version of Zoom. I'm not a fan, but it is better for you when you don't have to go all the way downtown in a different building, in a different place that might make you or your person that you're acting upon uncomfortable. So then we draft a petition. The petition can be as specific or not specific, but the general gist of the petition is that somebody is petitioning, asking the court to be appointed as guardian. You can have more than one guardian. That might be another question you have. Generally, I try to limit it to two because if you have too many cooks in the kitchen, you never know what you'll get. Then you go to court. Yes, you go to court. It's about a half-hour proceeding in court. If it's contested, it could be a lot longer. And there's a lot of paperwork back and forth. So that's the general process. It is best to do it with an attorney. It is easier with an attorney. When you are working with an attorney, you need to interview the attorney and make sure you are comfortable with them and that they have a breadth of knowledge because it is easy to mess this up if people don't know what they're doing. For instance, I was talking to a colleague last week. He's done his first guardianship, which yay, good for him. But he didn't ask for the accounting to be waived. So that poor family is going to have to do an accounting when it's not needed because he didn't know to ask. And that's not to judge him, but you don't know what you don't know until you know you don't know. And it's good to work with somebody who knows what they're doing. Yes.
How soon can you start the process of guardianship? Do you have to wait for the child to be 18?
It's a very good question. So I file when I can before the person turns 18. We do not go to court until on or after the 18th birthday. I have been on a committee for a little over a year now. We've been reworking the Indiana guardianship law. And there is a provision from Arizona that I introduced that hopefully will go through with all the updates when we do that, that says you could petition 6 months before. But at present, by operation of law, which is legally is for automatic, it expires upon the 18th birthday if you go in early. So you want to make sure you wait until they are 18. Now, sometimes colleagues will say in their petition it's because of a disability, it's not because of an age. And so I've done that before in emergent situations. I prefer not to gamble with your money or your time. And if we have to go to court twice, I feel like we could bond over other things instead of going to court twice. It also depends if it's a minor. Clearly, that's a whole different set of facts, too. So it just depends on what we're trying to do here. The physician's report, here it is. This is what it looks like. So you can see a physician licensed to practice medicine in Indiana. If, however, you have somebody at the Mayo Clinic or another state, that's okay too. I'm just showing you an example on the person, the alleged incapacitated person. The examination has occurred within the last 3 months of X date. That's just making sure that there's not a 10-year-old physician's report that we're basing this off of. I was different 10 years ago. Were you? Okay, I'm just saying. So the nature and type of disability and capacity, autism, Down syndrome, any anxiety. That was one the other day. I'm like, oh, if anxiety is a requirement for guardianship, I don't know, depending on the day. As much information as possible with question one, and then their condition when appropriate as well. All right. So, what kind of MD? I would suggest you have an MD who's familiar with why we're going for guardianship. It doesn't have to be a super expert, super expensive doctor. And then continuing on, this is the continuation of the physician's report. So what I did was I divided it into 3 slides so you could actually see what it is. And this is Indiana. This is not any other state. So they may use something similar, but this is specifically Indiana. And it's in your slides, so you have it. So the kinds of decisions that a person can and cannot make. I mentioned earlier, you can do a limited guardianship where you specifically can go to the doctor's office with that person. Maybe that's all they need. Maybe they don't need anything else. I work with a lot of parents who have kiddos with special needs. And if that's the case, I tend to side on not limiting your ability to help your child. I would much rather go to court once, get you full authority, allow you to have as much independence as possible, because I want to make your life as easy as possible. All right. You make all sorts of decisions every day, right? You chose to get up, you chose what to wear, you chose what you ate or didn't eat, you chose to drink coffee, because that's a choice. So it depends on your choices. So much like that, when you're considering guardianship, power of attorney, wills, trusts, anything, these are all good choices to consider and tough ones. It's not what's for dinner. Oh, I had Chinese last night. That stunk. Okay, let's do Mexican. These are bigger choices. So something to think about. Nothing is Chinese food. I'm just saying. All right. The last part of the physician's report here, the most appropriate treatment is what? The facts and supporting the opinions. You can have more than one doctor's report. You are not required to have more than one doctor's report, but you may if you want. The person can or cannot appear in court. All right. Can or cannot appear in court depends on the county. If we're talking Marion County, Hamilton, Hendricks, we can all do those all virtually. If we're talking Allen County, Magistrate Houck doesn't believe in Zoom, so we have to go in person. So it depends. But if the person cannot, another sticky thing about guardianship is to make sure that the person we're talking about has received notice, has been talked to, because if it were you would want to be talked to. Okay. Another thing to talk about is incapacity. We've talked about it a little bit. It's a tough word. It's a tough word to hear. It's a tough word to say. It's a tough word to swallow. So incapacity, and I have a lot of judges that are very good at what they do, and we make the point, incapacity does not mean you don't have value. It just means you need a little extra help, and that's okay. Unfortunately, there's not a better word at this time. So what are your responsibilities as guardian? You're supposed to be familiar with the person you're guardian for. I don't know if you've been on Netflix. There's this documentary that's really disturbing called I Care a Lot. This lady serves as she dupes senior citizens into becoming their guardian, hundreds of them, and then steals their money. Unfortunately, that happens. So you want to be acquainted with the person that you are serving as guardian. You want to be responsible with their money and assets. So I had a couple actually in the last year, a couple of cases where a minor needed a guardian. So we went to court either because of a settlement, direct inheritance. The facts don't really matter other than they needed a guardian and they were a minor and they received funds. So we went to court, Marion County, for both of these cases. We appointed the parent in both of these cases to serve as guardian over the estate of their minor child. The minor child received funds. So in the state of Indiana, the go-to process and procedure is to appoint somebody as guardian of the estate, then set up what's called a restricted account. A restricted account is one where the only way you can gain access to it is to petition the judge each and every time you want access to it, which is a huge pain, yes. But if you're trying to preserve the funds of the minor and make sure the funds are being used for the minor, that would be helpful because we don't want to run away with the money in that situation. Does that make sense? Unfortunately, in both of these situations, the parent chose to steal the money for other reasons. One to the tune of $92,000. Another went to a cash checks plus place and paid $4,000 to cash a $24,000 check. So that's $4,000 that child's not going to get anymore. So it's important to work with somebody who knows what they're doing. It's also important to follow what the court says because both of those situations, the people ended up in big trouble with the court. And we don't have time to be in trouble. So more responsibilities of being guardian. You can do estate planning in certain circumstances. Is the person easily taken advantage of? Do they answer yes to every single question? Do they long for friends? Can they handle money? And again, I'm not talking about making bad decisions. I'm talking about cannot cognitively manage their money. Are they responsible? Do they make their healthcare decisions? Do they go to the doctor? All things to consider. All right, now we're getting to your question. I promised we would, and we're here. Power of attorney. The most important thing I can convey to you about power of attorney is that you retain your own rights. If you have a power of attorney document drafted or an appointment of healthcare representative, you retain your own rights. Nobody is taking anything away from you. So I made a reference earlier to riding a bike. So when you have somebody helping you, so my dad, he would run alongside me. If I'm riding the bike and he's running alongside me, I would have to tap him in to get his help. Under a guardianship, he is on the bike. So that's a good analogy for you, I hope. Does that make sense? Like you're on the bike, driving the bike with the person, allowing them under a guardianship to the extent that they can be independent. But under power of attorney, they can only help, you can only help a person as power of attorney if they ask and if they consent, unless they get to the place where they're incapacitated. So everybody needs a power of attorney. Everybody over the age of 18 needs a power of attorney unless guardianship is more appropriate. There are two camps, healthcare and financial. I've been trained through the years that it is better to have healthcare in one document and financial in another document. I know some attorneys draft it in the same, and there's nothing wrong with either, but there are two camps of that. Supported decision making. So we've talked about power of attorney. We've talked about guardianship. There's this thing called supported decision making. So let's talk about that. Supported decision making effectively is a contract that says you can consult with whomever is making the decision. So if I had a supported decision making contract drafted that said my parents can consult with me, that's what that would be. It does not, I'm the one naming them as a supporter, but it does not give them the ability to make decisions for me. Unfortunately, in a lot of respects, I have not found a lot of use for it in my practice as of yet, hopefully one day. Because why would you have a document drafted that says you can do something you can already do without that document? I can talk to my parents about whatever I want, whether there is a contract or not saying that they're a supporter. We're very open. Not everybody is. So I was at a conference a few years ago, and there was a gentleman with special needs who said, I got rid of my guardianship and I have a supported decision making agreement, and that's all I have. And there was a doctor and his mom was on the panel. And I asked the doctor afterwards, I said, okay, I'm all about learning. So maybe I'm missing something. But if something happens to that child, adult with special needs, and he's incapacitated and cannot make his own medical decisions, where's the authority to make the medical decisions? Yeah, he can have the support of his mom, he can have the support of whomever else, but where's the authority to make the decision? And the doctor says there is none. So when you hear this people from the state of Indiana Disability Services present on this, a lot of times, unfortunately, they present it a bit misleading in that it can replace a power of attorney or guardianship, and that's not the case. So when else would a supported decision-making agreement be helpful? I've had a lady, 18-year-old in my office the other day that is paranoid. Everybody's out to get her all the time, and she's not about to sign a power of attorney document, and she's not incapacitated, so guardianship's not really appropriate. But she was okay to have supporters named. So when I talked to the doctor after the panel, he said it's a good intro document. So if somebody is a little leery of signing any legal document, this is a good starting place. It can also be used in conjunction with power of attorney and guardianship. But hear me when I say it does not replace power of attorney or guardianship, because that's really important to hear. I hear presentations like that are misleading and it makes me angry because it freaks you out because you're not given the correct information. Question, Lydia.
So with this supported decision making, does that require certain like these supportive people that are listed to be involved in decision making? Like versus just expecting the person to ask them to come in or other people pressuring them to decide on their own?
It does not require them to be involved. It just simply says that they can be involved if the person tags them in as a supporter. And we all need support, right? We all need it. We're not alone. Okay. So at least that's how I run my office. I have 3 assistants that I could not do what I do without them. You know, I have a mother that, God bless her, when she goes, hopefully not for a very long time, it's going to be a different world for me. We all have a community. We all have a village, right? Yes. Okay. Ooh, another question.
So that refers to medical decision making.
We can draft it to cater whatever support the person wants,
Well,
not just medical.
In New York State, we have what we call healthcare proxies.
Uh-huh.
So I'm referring to an adult son right now. He has 2 healthcare proxies who are sitting right here.
Yes.
But you make that decision only when they can't.
Correct. Yes.
So would you need more than that then?
No.
Because he's not firm. He's not, but
So with a proxy, the way I understand that word to mean is that you're his healthcare representative. Is that what you're saying? And so that's something else that gets missed too under power of attorneys. On financial, it can be effective immediately upon signing. Good question. On healthcare, it's only if you're incapacitated. You cannot jump in front of somebody if they have capacity to make their own decisions about their healthcare. Would you want somebody to jump in front of you if you had capacity? I don't. Yes. Yep. Yes. Until the person is incapacitated, you cannot just take over their healthcare decisions. Yes. Now, that doesn't mean that you can't go into the appointment with them and consult with them and be their supporter and all of that. That doesn't mean that they can't sign a HIPAA release at a doctor's office that gives you the authority to call in and make appointments, call in and ask questions. That's not what that means. You can still do that. But as far as taking over and making those decisions, not until they're incapacitated. You're so welcome. Thank you for the question. There are resources here, and they are on your slides. So you're welcome to look it up. And supported decision making isn't bad. It's not bad. It's just not super useful at this point in time, I have found in my practice. And unfortunately has been the result of a law on top of a law, because we never have those. It came from an anti-guardianship sentiment when there were too many guardianships, because just because you have a disability or a special need or you need help does not mean you need a guardianship. That's where it came from. Just so you're aware of that. Okay. Oh, yes.
You
Yes.
mentioned all of these things, but I feel like I've also heard the term conservatorship.
Yes. Conservatorship is guardian of the estate.
Oh, all right.
Yes, of course. Question over here. Thank you.
For the, what is it called? The decision making.
Supported decision making. Yep.
Yeah. So the person involved, my daughter in
Yeah.
this case, would they have an interview like with? I thought you go to court for the conservatorship.
You do. You go to court for the conservatorship or the guardian. Yes.
And supported decision making, you just.
Supported decision making, not that I'm a big proponent of pulling documents off of the line because you never know what you're going to get, but you can find them online at the links that I've provided in the slides. You can meet with an attorney like myself to talk more about it, to make sure that they're tailored pursuant to your daughter's wishes.
And you could decide to, can you do, no, we want to make sure we look at her financial and her
Mhm.
medical, and
Yes.
the rest would
Yes.
be her decision.
Yes.
Okay, no, because I took her to the doctor last week and she broke her foot in December,
Oh,
fell
I'm
again,
sorry.
and we think she broke another bone. And
Oh,
she said, I want answers.
yes.
She's 17 and a half. And the doctor said, what do you mean? She said, I want an x-ray. And we didn't want her to have an x-ray because she's had so many. And I was like, wow, she's actually deciding. And the doctor said, oh, you want the x-ray? So that's why I'm concerned. And I
Right.
told
At
you we
18,
should
if you have power of attorney, you
then-
cannot force her to have the x-ray and that procedure. Even under a guardianship, you cannot force somebody to have a procedure. So assuming she has the ability to voice her own opinion and decisions, you as guardian should be listening within reason to the person you're serving as guardian for. So something else that has been brought up in recent years is having someone's tubes tied and asking for that to happen because they don't want a baby coming that they didn't anticipate coming. That is not something that judges, in my experience, will grant, because that is a very hot topic. And I don't want to put a judge in that position of having to grant that wish or consider that wish. I hope everybody follows what I'm saying here. So we've talked about birth control pills. We've talked about all sorts of different alternatives than that if the person is unable to consent. And maybe that goes beyond the scope of your question, but I hope it was helpful in contributing.
No, it was good, but also for guardianship, you have to go to court every time you want to change something, right?
Not every time. No,
Oh,
not every time. But say that you and your daughter are at odds and you want her to have that procedure where she is tying her tubes, let's just say for sake of discussion, she disagrees, you want this. The doctor won't do it because your daughter is saying no. You have to go to court in that situation. If your daughter owns a house and you want to sell the house, you have to go to court for that situation and get court approval. But no, on the day to day, you don't necessarily have to go to court every time. But also, by going to court, especially in the first situation, it covers you. And that's good because ultimately the judge and the court is overseeing the guardianship.
okay. Thank you very much.
And I think the lady next to you had a
Not really a question. In California, we have conservatorships.
yes.
And they are overseen by regional senators. Or initially, that's how it's facilitated.
Yes.
To his question.
Yes.
And they can be for the estate and the person, like a general conservatorship. But
Oh,
they've
okay.
gone to supported decision making with
Uh-huh.
the regional centers. And it's
Yes.
a huge, very hot topic right now.
Yes, it is very.
Because the intention was good.
Yes. Oh, 100%.
But-
And I'm not trying to imply
No,
otherwise.
but the implementation is not
Yes.
practical in so many situations.
And a lot of times judges don't know what to do with it. And that's also a problem. You've paid for a document and you're in front of a judge saying, I should be able to do this. And they're like, what is this? So you're borrowing trouble really at this point, I think. But in California, I've had some people move from California to Indiana. That is a whole different situation. They are very much more in your business all the time. They may not be for Medicaid because there's no resource limit there. Somehow they're making that work for now. But for guardianships and trusts, and I don't necessarily think it's a bad thing, but there's a lot more oversight in California than there is in Indiana in that regard. Yeah. Every state's different, which is a good point to make. Guardianship is a federal term, but how it's carried out in different states can be very different. All right. Do you need a will? All right. So audience participation, get ready. I'm not going to call on anyone. This is a group question. If you have a will, can you avoid probate? That's the question. So if you have a will, can you avoid probate? Who says yes? Raise your hand. Who says no? Raise your hand. Who says, I don't know, but I would like to know? Nice. Okay, excellent. So the answer is no. You do not avoid probate by having a will. That is the answer. It is good to have a will, but you do not avoid probate by having a will. I love that. What is probate? Hang on. Strap in your seats. What is probate? Literally, look at that. And I've written down all of the notes for you, so you don't have to take those notes down. You can write other things. But anyway, so I did not plan that or ask her to do that. That's so great. All right. Probate assets. So probate is administering your will. That is what probate is. Probate assets, which is what your will controls, are land, car, house, and real estate, not beneficiary designated things. So if you have a life insurance policy that has a beneficiary designation on it, we're not talking about that. If there is no beneficiary, we are talking about that. But if there is a beneficiary designation, we're not talking about that for purposes of what your will controls. So first you ask what probate assets are in your individual name. If your house is in husband and wife's name, that's not an individually owned asset, as an example. So it's not a probate asset as long as it's jointly owned. So what probate asset is in your individual name? What debts are your individual name? Then you subtract the debts from the assets. And if in Indiana, you heard that, right? Not California, not Vermont, in Indiana, if it's $100,000 or more, a probate estate is needed. A probate estate is, so in your will, you nominate somebody to be your personal representative or executor. You are not appointing somebody, that's a judge's job. Much like you're not appointing somebody as a guardian in your will, you're nominating them. So in order to have somebody be able to act and administer your things, they have to be appointed as personal representative if there's $100,000 or more in Indiana in their individual name. So that's what probate is. A lot of times when somebody comes to me, they'll say, I need a will, or I need, no, that happens, but also I need a trust. And I'll say, okay, we can do a trust, but we're also going to do a will. Why are we also going to do a will? Because my life is exciting enough. I don't want to get sued. Okay. And if something doesn't end up in your trust that you had intended, your will can operate as an insurance policy for your trust, as an example. So with wills, there's two types. There's a standalone and there's a pour over. Standalone is it goes out, ABC, we call it a day, move on. It's not as simple as that, but just for purposes of example. A pour over will is it pours into a trust. So those are the two types. All right. Any questions? It's a lot to unpack there. All right. So we've talked about guardianship. We've talked about power of attorneys. We've talked about supported decision making. We've talked about wills. We've talked about probate, only to list a few things. Now we're going to talk about public benefits. So I lay this slide out because I find it extremely helpful. When you're helping somebody with disabilities or special needs, it's really important to know, one, whether they're on public benefits, and two, what public benefits they're on, because how you advise them can be different. So when you have means tested public benefits, what that means is there are resource or asset limits, income limits, and there's a disability test. So in Indiana, the threshold for this is $2,000 in countable assets. I did say countable assets that a person can have and be on Medicaid. So if they're on SSI or Medicaid, they can only have $2,000 in countable assets. There are things like a house, like a car, that do not count, but generally speaking, that is the threshold. So if my parents have 3 kids, myself, my sister, and my brother, if they want to leave something to my brother and my brother is on Medicaid, they cannot just leave it to Matthew directly. They have to do it differently because otherwise he's going to be kicked off of Medicaid. And I'm just giving you a broad scope example because we can dive deep, a lot deeper. The middle column is called an entitlement benefit. An entitlement benefit, public benefit, means that it's not enough to be disabled. You also have to have paid into a record or have somebody else who has. So it's great that you're disabled for purposes of the first column and you don't have to have a work record, but for the second column, you do have to have a work record. If you have something in the middle column and something in the first column, you still have to be aware of the $2,000 resource limit or whatever resource limit your state has. So I lay this out not to go into significant depth on the various categories other than to make the point that there is a difference. So I serve as trustee of about 38, soon to be around 40 special needs trusts for 40 individuals. Each individual is different. Each need is different. Whether they're on SSI or SSDI could be different depending on the circumstance. So I need to know that each and every time before I make a distribution so that I can inform the beneficiary or a parent or whoever their supporter is that I'm helping what the consequence is, good or bad. That is your slide to treasure. My mentor, David Lillisan from Florida, created it, and I think it's awesome. So there you go. Social Security. Let's dive into Social Security. There's a 4-question process, and I've laid this out to you. When we were creating slides for this conference, one of the things we were told about is not to inundate you with words. I don't generally do that anyway, but I have with these next few, that way you have it. It's laid out, it's spelled out. You don't have to write it down. Question 1, do you have a condition that has or will last 12 months or longer? If yes, move on to question 2. If no, game over. Question 2, can you engage in substantially gainful activity? That really boils down to, can you work? That's what that means. Substantially gainful activity is a term of art used by Social Security that says if you can make at or above 1620 if you're not blind, or 2700 per month if you are blind. If you can make at or above those numbers, you are not disabled. It does not matter. For purposes of Social Security, and by the way, Medicaid too, because in Indiana, Medicaid allows Social Security to make the decision as to whether somebody's disabled or not. And if Social Security turns you down, Medicaid will also be turning you down. And I'm specifically talking about adults, because as before 18, you're not going to get SSI unless your parent is not making a lot of money, because your income is deemed to them, meaning your income counts against their eligibility until they're 18. We have another question.
Just a comment more. In Pennsylvania, there is Medicaid expansion at this point.
Yes.
With Medicaid expansion, you don't lose that based on your assets.
Sure.
Yeah.
Yes. Every state is different, which is why I haven't tried to hammer it home too hard, but I'm only licensed in Indiana. So I'm only speaking to Indiana, but I appreciate the contributions about the different states. All right. Excellent. So if yes, if you can work, game over. If no, go to question 3. Question 3, have you worked enough quarters into the system to be eligible on your own work record or a parent's? If yes, you may be eligible for Social Security disability insurance. If no, go to question 4. Do you have countable assets that are at or amount to $2,000? If you have more countable assets than $2,000, you will not get SSI. If you don't, you might get SSI. Yes, sir. Question.
What is the number of enough quarters? How many is that?
Around 40.
So a quarter every year is
Yes, over about 10 years. Yes. It also depends, because if you have a child with special needs working part-time, they could, over, I want to say 2 or 3 years, have enough quarters to start drawing. It may not be as much as an adult who's paid in over a lifetime, but that is a possibility.
So how does the parents' work history and contributions to Social Security affect the child's SSDI? Are they eligible for SSDI just for a certain number of years or lifetime?
Lifetime, potentially. If the parent is retired in drawing, disabled in drawing, or dead. Those are the 3. If the parent is doing one of those 3 things, or I did say retired, I said that. Okay. One of those 3 things, if you're drawing, your dependent with special needs could draw off of your record. But if you're not drawing, they're not going to be eligible.
And they can draw for a lifetime. And that's SSDI.
Yes.
Does that have a means test as well?
It does not.
So they can draw forever.
It does
regardless of means.
not, because it's an entitlement benefit in the middle.
Is it both parents have to be doing that, or
No,
just one parent?
just one parent. Yes. Now, something else to be mindful, since you asked that question, the higher earner, whichever higher earner retires, say second, it's not automatically transitioned to the higher earner parent. You will have to call and ask, because Social Security is not overly eager to give you money.
And do their benefits depend on the lifetime contributions of the parent?
As far as how much they get from Social Security off of your record, yes. Yep. Oh, question. Oh, yes, by all means.
I live in New York. My son is just turned 18. And as long as he's a student, he still gets Social Security disability.
Okay.
When he is not a student, then they have to prove that he can not work if he continues to get it.
Yes.
Or he has to work under a certain amount of
Yes.
hours. But so it's not lifetime guaranteed.
It's not, there are no guarantees.
Even though I get it too, because I'm
Right.
also disabled.
Yes.
And don't work.
Because thank you for sharing that. You start off with, do you have a condition? You follow it with, can you work? It's the same process. So it's not automatic because they have special needs in your drawing. They have to make the point that they cannot work. I appreciate you sharing that. Wasn't trying to contradict. Does that help clarify that? They cannot work above a certain limit. Yep. That's the whole 1620 thing. Yep. Yes.
There you go. Okay. So I'm trying to get my head around this.
Yeah.
So I live in Texas. My son is 20. So we applied for SSI and
Yeah.
we were denied.
Which is normal, by the way, to get denied the first, second, third,
So-
fourth time. Yeah.
Okay. So now we're appealing
Yep.
that. And what I worry about, so for SSI, it's means tested.
Yes.
Now, he can work in a supported employment environment and certainly wouldn't meet those requirements.
Numbers.
But we were never told about the numbers. Anyway,
Okay.
I give you that. But then SSDI has to be when my husband or I are drawing our
Yes.
Social Security benefits.
Yes.
And then we transfer it to my son.
The moment you start drawing, assuming your son has not worked enough to have be drawing off of his own work
Right.
record, you have to notify Social Security because nothing is automatic with Social Security.
And then what if that's over the $2,000 amount?
So there are categories where that I'm talking about assets when I'm talking about the $2,000. I'm not talking about income.
So he could have N through SSDI.
Yes.
It's more than 2,000 a month.
Yes.
That's okay.
Yes.
Okay.
Right. There's a yes. There is a I love it. All right. There is a lot more to this Medicaid than what I could present in the time I have. Yes. There has to be a spend down. You cannot indefinitely hold funds and not spend them. So if you've been on if you've received Social Security disability insurance for 24 months, then you could be eligible for Medicare. So it's not just somebody who's 65 or older, it could be somebody younger. Yes, to your point, there is a spend down. It's a little more nuanced than what again we have time for today, but I appreciate you guys sharing. It's awesome because it's not as though your son would get $2,000 every month and you can just stockpile it and it can just grow and he can still have Medicaid. You have to spend down or do other planning to make sure you can continue to be eligible. And this is why, by the way, I offer free consultations because as you can see in the various comments and questions, this can go in all sorts of different avenues. So we've gone through the questions for Social Security. We've dug deep into Medicaid, or at least a little deeper than an initial consultation or initial presentation. You'll always have more questions because I always have questions. I've had a lot of clients call and say, I'm moving out of the country. I just can't take it anymore with no plan. Please don't do that. Think before you do, because it's a lot more complicated. When you talk about estate planning, I mentioned my parents have 3 kids, Matthew, my sister Emily, and myself being the eldest. In order to preserve Matt's Medicaid, we cannot have his share handed to him like me or my sister. So you can give him outright inheritance, but if you do that, he'll lose Medicaid. You can leave it into a non-qualifying trust, something like a family trust. Third at 25, half at 30, the rest at 35, because you want them to be older, you want them to be more mature, and that's great, but that doesn't help for Medicaid. You can disinherit them. That doesn't sound very friendly, but it happens all the time. You can leave assets to the brother or sister. I hear that a lot, actually a lot more regularly recently. And the issue with that is, what if life happens to that sister or that brother? What if they're divorced? What if they die? What if they become disabled and have to spend down? That didn't quite go as planned. So it's good to get a plan in place. What if they get divorced and it's stuck in that process? That's not fun. I'm just saying. All right. So a special needs trust. Special needs trust is an investment tool and it's also a shield. So we've talked about the $2,000 limit and we've talked about spending down. Special needs trust is an exempt asset. It does not count. So you can put money into a special needs trust. You can leave Matt's third, as it were, to a special needs trust and it will not count against his $2,000 asset limit. There are 2 different types. And to keep this simple, because you can dive pretty nerdily into this too, there are 2 types. There's a first party and the third party. It really boils down to whose money was it originally? Did you get a lawsuit settlement? Is the settlement in your name? That's first party money. Are you getting Social Security? That's first party money. Did you get a direct inheritance? That's first party money. You wanting to leave money to your son that started out as your money is third party money. So why does that matter? It matters because the rules are there, but it also matters because in a first party special needs trust, there's a Medicaid payback clause required, meaning that upon your son's passing, if it was a first party trust, Medicaid would be entitled to be reimbursed. Give all the money that's left in the trust to Medicaid because healthcare is expensive. In a third party special needs trust, there is no Medicaid payback clause. So it can go to your other kids. It can go wherever you want it to go. So I tell clients a lot, I help with the what if to avoid the what now. A third party trust is what if. A first party is what now. So why is a first party trust a good thing? If you receive assets, say you receive $15,000 in a given month, and I'm just throwing a random number out there. There's no significance in the 15. They can't hold the 15 and be on Medicaid. You got to do something with the 15. And it has to be dealt with in the month received. So it's the second. So a pretty good timing as far as the beginning of the month. It has to be dealt with within the month of May if you get $15,000. So putting it into a first party special needs trust, allowing it to be invested, allow it to grow, allow it to be there beyond the month without counting can be very helpful. And so it is helpful when needed, but it's great when we can avoid it. That was my presentation. Okay. All right. I will take your questions.
So we have a will that establishes a third-party trust upon our death
Yes.
for our daughter.
Yes, that's great.
Should we also establish a first-party trust and have that ready to go?
I would not. And the reason
Okay.
why I would not is because if that is funded and it's your daughter, right? You said daughter.
Correct.
And she dies, it goes from the inception of Medicaid, of her being on Medicaid. So if she got on Medicaid at age 3 and you open the first party trust, put a little money in it, you're basically writing a check to the government.
Okay, so you have to fund a first-party trust when you open it. So you can't have it ready to go if she inherits any money
I
from
wouldn't.
whoever.
Right, exactly. I would only
But,
set it up
but
if
you
there's a
only
need.
have till the end of the month to do it. So if you get it on the 31st, you better be hustling.
Yeah, you better be calling my office. Yeah.
With the third party special needs trust.
Yeah.
Do you have to fund it in order to establish
You
the
do
trust?
not.
Or-
I'm
okay,
so
have
glad
it,
you
like,
asked
as
that
part of the will.
question.
Okay.
Yes. So in his will, he said he has a provision to fund a third party trust. Oh, I'm so excited you asked this because I get to share my favorite analogy. Okay. A testamentary trust is like a food truck of trusts. Okay. Go with me if you don't like this. Oh, I do. So a food truck doesn't exist until it parks and opens for business. Your will doesn't really function until you don't anymore. So food truck of trust, get it? Yeah, pretty good. All right. Indiana's a dry trust state. So that means you don't have to put $1 into it if you're setting up a third party trust. A lot of times clients will use something called survivorship life insurance. Survivorship life insurance is one where it insures 2 people and pays out at the second death. So it's cheaper to get a funding source for the special needs trust. But in Indiana, we're a dry trust state, which means you're not required to put money into it until if or when you want. Did that help?
Yes. Second
Awesome.
question.
Yes.
We have an ABLE account for our son.
Yes.
Which we have that system here in Indiana. I know a lot of states do.
Mhm.
A lot easier to utilize, I think, than establishing a first party special needs trust. Possibly.
It can be.
And it's up to like $100,000 you can have in there. But is that subject to a Medicaid payback?
It is. It is subject. So an ABLE account, which I did not include in my slides because I didn't think we'd get to it, but go you, bonus question round. An ABLE account stands for Achieving a Better Life Experience. The 529A account, which you can invest, you are limited to only whatever the gift tax exclusion is per calendar year. So 19,000 right now. And there is a Medicaid payback clause, but it is helpful, especially if you have that 15 and the person is eligible to set up an ABLE account, which means the onset of disability is on or before 26 at present. Next year, I think it'll go up to 46. So that's pretty exciting. But it's a good sidekick to a special needs trust. And when it can avoid a first party trust, that's helpful too. Yes. Did you have a question?
Real simple. So the
Oh.
category of law firm for this, does this fall under a disability lawyer? Is this a
That
family
is a
lawyer?
phenomenal question. Estate planning and elder law is what I would do. Disability lawyer often means Social Security because they go through Social Security. And I generally don't get involved with Social Security except if a special needs trust is calling into question. I have a colleague that's all she does. She's awesome. But I do know quite a bit about it because of my area that I focus on. Yes, excellent. Any other questions? I think we're at time, Lydia.
All right. Let's everyone give a round of applause for Liz.
Thank you.
Thank you.